Welcome, everyone. This is Catherine Wygant. I'm Catherine Wygant Fossett. I'm the Executive Director of the Institute for Family-Owned Business. This is part of our how-to series for the family business. It's COVID-19 challenges, legal, HR, and communications. So we want to welcome everybody for joining us today and to thank Key Private Bank for being our title sponsor for our how-to series. I'd also like to thank Maine Biz and HR Convention for also helping to sponsor us today. This is our first time doing a totally remote program. We have been doing remote programs for 5 years from Husson University, where people have remoted in. Generally, we had 5 to 10 people on that call, and now we're expecting over 70 people on this call today. So we want to welcome you. As many of you know, the IFOB is a nonprofit that helps family businesses succeed. We're all facing some challenging times, and we've adapted by bringing you new programming like today through Zoom, and we're moving all of our other programs online and postponed until later in the year. So we hope to, in September, be able to celebrate our Maine Family Business Awards. So we have nominations and other things going on now. We have over 50 programs, so this is going to be fun. We figure out how to move them all online or move them to later in the year, but we'll get through it. We also have some very exciting news. To fulfill our mission to support local family-owned businesses, the IFOB board and staff have decided to waive all new family business membership fees for the remainder of 2020 and to open our affinity groups to all family businesses to help you. So I know many of you are just experiencing us today, and we'd really love to get you involved and join the family. We'll be sending out an email with details on that later this week. Today, we have Dave Ciullo from Career Management Associates. Can you wave, Dave?
Morning.
Yeah. We have Linda Varrell from Broadreach Public Relations. Hi, Linda. We have Peter Lowe and Dan Stockford from Brann and Isaacson. All of these are family-owned businesses, and they're all here to give you their insights into HR, communications, and the law. We've muted everyone and turned off your video, but we do want to make this interactive as an interactive program. So please look down on your chat feature. Some people had sent questions into us ahead of time, and then we will also be monitoring the chat so that we have information there and can take your questions. After the program, we'll be sending you a survey and a gift. So please do fill out the survey, as this is how we build our programs. The next one in our series will be on May 6th, and we'll cover further COVID-19 challenges with HR, the law, banking, and health insurance. And now I'll turn it over to you, Dave. Thank you. Thank you, everyone, for being here.
Hey, good morning, everyone. How you doing this morning? We are going to have a great program today, and here's how it basically is going to run. First, we have Linda Varrell is going to be on. She's going to be talking about communications and how you are able to deal with it during this COVID-19 situation. She'll be talking about a perspective from management and the CEO and why things are being done the way they are. She's going to be talking about managing risks and what you can and cannot be talking about in regards to this as recommendations. Then Peter Lowe and Dan Stockford will be on, our great legal team. They'll be talking about the Families First Coronavirus Act and the Family Medical Leave Act, the emergency one, the layoffs and furloughs, how important they are today and how we deal with them, and of course the CARES Act. Then I'll come on at the end and we'll talk about some things that are on the front line of HR. We'll be tagging in with the stuff that Peter's talking about, kind of give you a couple of perspectives. And as we know, unemployment has jumped dramatically. What does that mean for business? And what are the perspectives there? So a lot of great stuff today. It's going to take about 2 hours. Again, put your questions in on chat. We do have some. As moderator, I will come on and ask some of those questions. Some of the guests will, of course, be doing it themselves, but I'll ask some of the questions from there. So we're going to get started. First, Linda Varrell, it's all yours. Linda, you're on mute. There we go.
Oh, perfect. Great. Well, thank you, David, for having me, and Catherine and the Institute. It's my pleasure, and I know everyone was up a little early today to bring you the program. So we're going to start out with crisis communication. And if you think about where we were 30 days ago, everyone woke up and realized, oh my God, our world has changed. And we are dealing with crises on varying levels across a variety of industries. Because in our planning for crisis, when you put your plan together, you think about worst case scenarios. And there are a lot of industries that have actually started thinking about pandemics a number of years ago and had put the plan together. But some of the questions that come up are interesting because they say, how come we weren't ready for this? Well, no amount of planning will solve exactly this situation that we're in today. But when you go through the planning process, it helps you understand, it helps you cope, and it helps you make good decisions. So the first thing I always like to talk about is what exactly is the difference between a crisis that everyone feels like they're in today versus simply bad news. And a crisis involves that triggering event. So for many companies, it is the pandemic. It's folks are ill within their organization. They're having to lay off. They're having to close. Every company, every institution, every organization has a different triggering event specific to them. The second piece is that there are victims and or perceived victims. And we like to talk about that because that perception of a victim is held externally. So while you may or may not think there are victims involved, you have to ask that question. And then there's something unusual about the event. Well, I don't think it gets much more unusual than it is today. And I think the word we keep seeing everywhere is unprecedented. The difference in a crisis, however, is the situation unfolds over time. The parameters exceed our in-house capabilities, thus, why folks are hiring attorneys and HR specialists, why they're hiring communicators, why they're bringing in logistics folks. It's simply because the parameters of what we're dealing with are exceeding our in-house capabilities. And then the incidences are prompting a deeper look by the media. And so these together constitute a crisis. And unfortunately, what we're dealing with today isn't necessarily a one and done. So why does this matter? How do we deal with it? How do we even begin to wrap our head around what's going on? And we talk about perspective. How do we gain perspective in where we are today and where we need to be, 30 days from now, 60 days, 90 days. And it starts with an understanding of the organizational structure of your company. So thinking about, what is the CEO and business are thinking about? Well, they generally are focused 3 to 5 years out. They're not thinking about what's happening in this moment. What about the head of operations? What are they thinking about? Well, their perspective is, how do I continue to drive revenue? How do I continue to run the company and have people show up and do their jobs? What is your CFO thinking about? Well, they're looking at, what do we have for funding today? Where is the financing coming? Where is the financing coming from? What does our forecast look like? And that's what their perspective is. And then your technology folks, you can imagine, today are really thinking about what does our system look like? How can our IT infrastructure handle what we're dealing with? Your risk managers are thinking about, how are we keeping everybody safe? How are we protecting our reputation? HR is thinking about it from a people perspective. How do we keep our people safe and motivated and engaged? And what do we do if we do need to lay off? We've got legal, there are legal ramifications. We can't just throw regulation to the wind and do what we want to do sometimes. And then finally, you have your marketing and your communications. How do we look to the external world and how are we positioning ourselves? And so in these times of crises, people ask, well, how do we communicate? What do we do? What do we need to be thinking about? Well, first, it's understanding how all of those perspectives come together, because it's not about, at this point, putting a plan together, but it's really understanding the process for establishing your communication platform. So the first thing we talk about is you want to be the first to tell your story. And that doesn't mean you run right out with a statement and say, here's what's going on with my organization, or here's what's going on with my situation. But it means that you're ready to tell that story when either the opportunity presents itself or when you're forced to do so, but that you've already put the energy into putting that messaging together and figuring that out, because timing really is everything. So being the first to tell your story and being as transparent as you can within the ramifications of the laws, with the governing bodies, and within some of the constructs. So today, we're asked, well, why can't we just go out and say certain things? Well, we're having to work within the construct of the CDC. What are first responders doing? What are communities doing? What are the state and federal government? What are they all doing? And so when we're putting our communication plan together, we have to be thinking about all of those different authorities that have influence on what we're going to say, how we're going to say it, when we're going to say it. The second piece is we need to research our facts and our impacts thoroughly. And one of the things that I say often is there's no such thing as BS in communication, in crises. You either know what you know or you don't know it, and then you need to go find it out. So you're researching your facts. What do we know to be true? And what do we still need answers to? And how are we going to get them? And who has those answers? So we're the first to tell our story. We research our facts and impacts thoroughly. So who's impacted? When did we know about it? How long has it been going on? What's been going on? Do we even have a good handle on where we are and how we're dealing with today's situation? And a lot of times that research takes place over time. So someone asked me, well, is it a one and done situation? And when you're in a long-term crisis like we are right now, your systems are set up differently. Your communications team is meeting daily, sometimes 2 and 3 times a day, because the circumstances are ever changing. It's a fluid situation. It's changing. And so we need to continually research those facts. So in order to be the first to tell your story, we talked about that it exceeds your resources. Well, this is when we need to be bringing people in from the outside and putting that communications team together so that we can do that work. Because if you think about running an organization, the HR person is doing their job, the finance folks are doing their job, the sales and marketing people are doing their job. And so having to stop every day and really think about what we need to be communicating about takes additional resources. So we're the first to tell our story, we're researching our facts and impacts thoroughly, and then we're assessing our audiences. And today it's kind of interesting because the audiences have changed a little bit. So we have our internal audiences, our employees, our vendors, our insiders. We also have our external audiences, our stakeholders, different folks who rely on the organization to be successful. They rely on the organization for their sustainability. But there are also new audiences, like I had indicated, the regulatory environment, there's the community, there's the government that now has an impact into what we're doing and how we're doing it. There are also folks out there that I call the watchers, folks who are keeping an eye on certain industries and certain folks and really injecting themselves into the situations. And so you really need to be thinking about who are all of our different audiences and where are concerns and questions and communications going to be coming from, and making sure we're understanding how we're going to be talking to those different audiences. when we're communicating through this process, it's a matter of being confident, it's a matter of being courageous, and that our message needs to be consistent. So we're the first to tell our story, we're researching our facts, we're assessing our audiences, we're communicating confidently and consistently. And if we say we're going to do something, we need to be doing it. If we set a precedent, then we need to be sticking with that precedent. Or we set a protocol, we stick with that protocol. And as we're communicating, we're evaluating and we're evolving. So in today's world, we're putting statements out there, we're monitoring the environment, we're looking at social media, we're looking at comments, and we're figuring out, how we're going to continue to provide information that's needed while maintaining, privacy, respect, maintaining consistency with the laws, maintaining consistency with the regulatory bodies that we're working with. So in this case, with this situation with the pandemic, we're working with the CDC. We're communicating with the governor's office. We're working within the system as opposed to against the system. So it's an interesting time today, because when we work with clients, we talk about, let's think about what is the worst case scenario that could happen and focus on those different events. And here we are. It doesn't get much worse than it is today. But we need to still be following what's trending, because some businesses are doing well. They're recession proof. They've pivoted. They're achieving their highest and best use by providing PPE or by doing something different. But when we're building our plan, we still need to be evolving. So are you dealing with a crisis right now? Or are you simply dealing with bad news and things that are going on within your organization? And there is a difference, but that doesn't mean we stop planning. So we're analyzing the past, following what's trending, and we're trying to anticipate what's on the horizon. And I know folks are looking for answers to things. That's, everyone wants to know, when are we going to reopen the economy? When a lot of folks can't even think about what are we going to do tomorrow. But that doesn't mean we can't be thinking about, okay, what if we can open on May 1st? So what is that going to look like? How are we going to communicate that? How are we going to bring people back on board? Well, what if we can't open on May 1st? What if I'm going to have to close my business? What if my business continues to grow? There's a lot of scenarios that your communication team needs to be working through and anticipating what's on the horizon. And as we go through the risk management, and I'll share a little bit about, we were working with a large client that was hosting an event, and we were right at the cusp of, should the event be canceled or should it not be canceled? So this was early in March. The state of emergency hadn't been impacted yet. So how do we make those good decisions? Well, we went back to the various perspectives, finance, operations, people, and really looked at what's our risk in all of these different areas. So if we continue to hold this event, are we going to be able to get volunteers? If we hold this event and we have 50% less attendance, what are our ticket sales going to be? What's the financial impact going to be? If we hold this event, what's our reputation going to be if in fact, people are getting sick, or we can't handle the additional work of cleaning or doing different things along those lines. And so we had to go through the entire risk management process of figuring out, are we going to get the volunteers? Are we going to be able to handle this operationally? Is it going to even be financially viable to move forward? And what is this going to do to our reputation? So in a crisis, our challenge is stepping up and really having to do more thinking and more strategy in the moments when you don't have enough information. And many times people ask, well, why is it organizations don't do a good job communicating? And you saw it in the last 30 days. The first huge barrier to effective communication is we're in denial. We're minimizing the situation. We're in denial. It can't happen to us. It's over there somewhere. And all of a sudden it's on your doorstep, and we haven't been doing the planning. We're not ready because it's exceeding our internal resources. The second barrier to response is really business strategy and structure. So if you haven't been doing the planning, you don't have the legal team on hand, or you don't have the communications team on hand, and you're now having to go out and bring those resources to the table, bring them up to speed, those are going to create delays and lags in communication. So your business strategy, your structure in your organization, you might have proprietary processes. You don't want to bring anyone in from the outside. We can handle this. We don't want anyone to see how we do our work. We want to take care of it ourselves. You could also be hamstrung with local, state, and federal laws. Is that keeping you from communicating, or at least putting your best foot forward? And what about safety and privacy? And of course, there's always the lawyers. My good friend Peter's on, and so we're looking forward to hearing what Peter has to say regarding communication and working with our employees and different things along those lines. So with that, I will stop for a moment and see if we have some questions.
Linda, one of the questions, can you hear me? It's David.
I can hear you.
One of the questions came up is, as an organization, what should I say to employees to keep them still engaged or keep them still positive? Or what should I say to the public, as I don't want to tell necessarily the public I'm in as much potential trouble as I am? How do I manage that from a crisis communication standpoint?
So what I'm hearing here are really two questions. So the first one, I'll answer them in reverse, is, how do I say to the public that I'm not necessarily in trouble, or I am in trouble? Can you read that again?
The question is, and I'm paraphrasing.
Okay.
I may be in more trouble than I want to project to the public. And how do I communicate as being as honest as I can, but not necessarily, dry up my revenue?
So, okay, no, that's a great question. And so when we're talking about where we are today, we can look back in the past, or we can let go of the past, embrace where we are today, and figure out where we want to be for the future. So in crisis communication, that we talk about what's going on right now, but then also what are we doing about it, and where do we expect to be? So it's getting that reflection, getting that projection into the future of, here's what's going on. And you don't need to be saying, we're losing hundreds of thousands of dollars or whatever. Here's what's going on. We're having to reevaluate where we are. This is what we're projecting to do. Here's how we're going to handle it. And here's what we're hoping our future is going to look like. You're not over-promising, but what you're saying is, we've got a plan and we have a vision for that future. And so that's what a lot of companies we're seeing are doing, is that, we want to put in the spade work right now so that we can build that vision for what our future is going to be for when we come out of this. I don't know if that answered the question, but it's that future focus, giving people hope that you're on it, you've got the passion, you're digging in, you're going to do what you need to do to save your company. Now, as far as speaking to your employees, you want to involve your employees in that process and be very transparent with them. Here's where we are. Everything's on the table right now, but I need your help. You have a role in this. How can we best support you? What do you need from us in order to be most successful in your role, whether it's, you know, they need to work in the mornings, or they need to work in the evenings, or they need to actually take a break right now. It's really bringing everyone to the table to help with that decision-making process, especially in a family environment or in a small business, giving everyone a role and then trusting them to do that role.
I'll come back on the screen as the moderator here. And Linda, one of the other questions that came up is, what if we have had a potential COVID crisis at the facility? And we do have the public that may come or not come to our facility. How do we handle that from a crisis communication standpoint?
Yeah, so that, you know, that's a very real question and a very real situation. So first and foremost, you need to be partnering and communicating with the CDC, and you need to be speaking with your local government, whether it's city, town, et cetera. So there's a responsibility in two different areas. Number one, to maintain the safety within your organization, and Peter will talk a little bit about that regarding OSHA. So if you have a known positive case within your work environment, your folks need to know that. And you need very specific steps in how you're handling the privacy of that person. So because they do have a right to the privacy, there are HIPAA laws. So sharing exactly who the person is not within your legal realm. So yes, we need to be saying there is a case within your organization or within your facility. You're working with the authorities on establishing and the highest best practices, and you want to be giving people a place where they can go to get more information. So we're going to be posting to our website, we're going to be posting to Facebook, we're going to be sending notices out to keep people informed as to what's going on, what we're doing about it, and how you can get more information. And given the situation today, some hard decisions need to be made in terms of, are we going to limit who's coming into our facility, who's who's essential, who's non-essential, and how we're going to be setting up those parameters. So that goes back to the different perspectives in terms of how we're going to make decisions, because those decisions are operational. They're not from a crisis communications perspective, but they all have to work together. Those decisions need to be made before they can actually be communicated. Oh, you're on mute.
We will get used to this. The last question here really focuses in on the language. And as you know, when you're putting things out in writing, especially on websites or different areas, how important it is to be very careful to have that language scripted or looked at in terms of that.
It's very important that that language is scripted and or looked at, especially when you're coordinating your communication with local, state, and federal agencies. So if you're working with the CDC, then you want your messaging to be congruent. You want to put forward whatever best practices are being recommended at the time. Today it's now about wearing masks and requiring folks, within a facility to be wearing masks, or within an organization. If you're going to come to work, then we want you to be wearing masks. 2 weeks ago, that wasn't the requirement. And so your messaging needs to evolve, and the language needs to be very consistent with what those best practices are.
Okay, great. Thank you very much, Linda. We will move on to the second phase of our program, which is we're going to be talking next with Peter Lowe and with Dan Stockford, and they are going to be coming on here, and they're going to start their videos. There we go. We'll get everything working on here. There we go. Hello, Dan. Hello, Peter.
Good morning, Dave. How are you?
Good morning. We're doing well. Well, obviously, there's nothing really going on in the legal side. This should take a couple minutes, I'm sure. I'm sure there'll be no questions other than the 2 or 3 pages that have already come in terms of questions for you. But we'll let you get started with the program. Thank you very much for joining us today.
Thank you very much. And if you can't hear the audio well enough, let me or Dan know. I know it can be a little variable. The first thing is, Dave, I was quite surprised. I wasn't surprised that lawyers were deemed essential, but HR consultants as well. That's quite remarkable.
It is impressive.
I asked for your camera to be left on, so at least I could see you cracking up with laughter in the background, even if I can't hear you. It looks like the person controlling this is the ability to mute you, which is a wonderful facet of these Zoom calls. In any event, yes, Dan and I have been in the trenches, as many of you have, for the time blends and blurs, doesn't it? But should we say 3 weeks, 4 weeks? And we have had questions of a volume and a variety and of a nature that none of us ever anticipated. And what we have done when we have had the opportunity, and thank you everybody for joining us, to speak to folks in a webinar, it gives you as much as we can the sort of the practical advice that we're offering clients day in, day out. And so rather than walk you through the facets of the new laws that are out there, the new guidance, sort of point by point, what we found is most instructive is to talk about the questions that we're getting. And so Dan and I will go back and forth, and Dave, please, throughout this, pepper us with your questions as well. I know you do already. And we'll have one of our associates who works with us, Hannah, I think she may have just put something up in the chat column, but she will post some of the alerts and other information that we've been sending out. I hope those of you who are on the mailing list don't feel too inundated, but it's been a constant stream of information, and we read things that come out from the federal or state government, and we realize that there is valuable information that we feel we should pass on. And so you'll see some of those alerts come up, and you can get them directly from us as well. I know out there in webinar land, there's some folks I know from businesses and nonprofits, and they know me well enough that probably my least favorite topic in presenting many times over the years has been the FMLA. It's kind of a running joke in our firm. And I have no disrespect for the FMLA. It's just never been my favorite topic. Give me a tricky sexual harassment case to provide legal advice on any time. But we are in this new world where all of a sudden everybody is asking us questions about the FMLA. And I observed this to one of my colleagues the other day. The questions always came from HR, and there's a wonderful wealth of knowledge in HR about the FMLA. We're getting those questions now from the C-suite, from the chief executive officers, because it's reached that level. So what we'll do is we're going to talk, as I said, through some of the really practical questions we've received, and they've shifted over the 3 weeks, as you can imagine. And one of the things that we want to be able to talk about this morning, not just through some degree of optimism, but practicality, is what you should be thinking about in terms of return to work. And there's some important issues that we want to highlight and emphasize right away. I'm going to start though, Linda. Thank you for your comments. Linda is a great asset and is there when crisis hits and hopefully for the great majority of you, we're all dealing with a crisis, whether it's individually impacted your business. It'll be varying degrees, just as she said. But I think everybody has to prepare themselves for the situation where an employee, assuming you still have folks working, and I recognize many businesses have had to shutter themselves temporarily and place their employees on furlough, or the great majority of them. But you have to be prepared for the situation when one of your employees tests positive for COVID-19, or, as we know, because of the shortage of tests, is deemed to be presumptively positive. It's amazing how we're using all these phrases and expressions that we'd never heard of before. We readily adapt our vocabulary. And Dan and I were talking about that very question last night, which was, I think one of the clients he works with had an employee, and we've had many of these situations now, unfortunately, where someone has tested positive or is presumptively positive. So Dan, I'm going to put that one over to you. You get the call from the client, and it says, yeah, we operate a manufacturing facility. We've learned that Peter Lowe tested positive. He's not in work any longer. He has been working. We have 75 employees who work in our manufacturing plant. What are my legal obligations, and what would be best practices in this area for informing other people about that positive test? You want to tackle that one, Dan? If it looks like you're not on mute.
Yes, I will. The advice that we've been giving to employers when they have employees that test positive and have been in the workplace is to share information about the fact that there's been a positive test or presumed or employee that's presumed to be positive, but not to identify the specific employee. Now, it often gets out through other means, and often people will jump to conclusions about who it is, but because of confidentiality restrictions under the Americans with Disabilities Act, we recommend that employers don't use the employee's name when sharing the fact of a positive or presumed positive, in order to protect the employee's confidentiality. But as I said, it may be fairly apparent to people, depending on the size of your workforce, who the individual is, and from our view, that's an acceptable risk. We think it's only fair that other employees know that there's been a positive, and they have that information. Obviously the individual employee, should not be in the workplace, and we'll talk more about the federal act that allows some level of paid leave benefits for employees who are out for COVID-19 related reasons. In addition, it makes sense that when there's a presumed positive or a positive, to reevaluate your workplace practices. And if you've got employees coming in to work, you should have measures in place to encourage social distancing, regular cleaning, all consistent with OSHA guidance and CDC guidance around a safe workplace. So those are a couple of things to think about when you confront that situation.
Yeah, and you'll hear this, you've probably heard it from us before, and you'll hear it from us again. We're in a time where our clients are dealing with competing risks, and you're never going to make a decision that's going to immunize you from risk or potential liability. And I lean towards providing more information to employees who are still working so that they can make the best judgment about the actions they need to take. So I've given advice that you may indicate when the person who has tested positive last worked in the facility. If it's a 3-shift operation, you may indicate which shift they worked. Some of my employment law colleagues would start to wonder whether, I'm outing that individual. And in the end, my justification would be, how do we best promote safety within the workplace? How do we best safeguard the welfare of all of our employees without going over the line and specifically identifying that individual? And so far, so good. And we've given quite a lot of advice in that area, and I haven't sensed any significant backlash.
Peter, there's a couple of related questions in the chat that I'll pose to you.
Yeah.
If your employees are all working remotely and therefore don't have contact with each other, is it necessary to inform your workforce of a positive COVID-19 case?
Yeah. If the timing would indicate that there is no risk of exposure because you've been working remotely for the last 3 weeks, I don't see that you would have that obligation. It really is an obligation, I think, under what we would call a duty to warn. It's not, frankly, written into any law. I think I saw a question earlier. Somebody had a good knowledge of OSHA, which OSHA has this very general standard that you must provide a hazard-free workplace. And of course, the workplace and the concept of the workplace has expanded beyond the 4 walls of the factory or the office to where we're all working remotely now. But that's a really good question, and it's always going to be circumstantial, but if it's been long enough, I'd say no. You said there was one other question, Dan?
Yeah, and Linda may have some insights on this as well. Should you communicate to your clients that you have an employee with a positive COVID-19 test if you are not client-facing?
So if you're not client-facing, I don't see that you would have any legal obligation to communicate that information. I think that, again, the motive for informing individuals about that information from a business point of view would be if there's any potential exposure. So from the legal point of view, Linda, where are you on that?
Yeah, so one of the things that you want to be thinking about are those different scenarios. So if we have a employee, but if you have, say, an officer level employee or someone who is essential to the organization or essential, to the future of the organization, you may need to communicate that. So if you're looking at, your organizational chart, are there key employees, and do you have a communication plan if for some reason that person gets sick? And then again, it goes back to the privacy issue. This is one of those gray areas. Do they want you to tell their clients? Like, let's say in my case, one of my key employees who is client facing, we need to have a plan on if they do test positive or if they're unable to work, how are we going to communicate that? So it really is a case by case basis and where they fit in the sustainability of the organization.
Yeah, thanks, Linda. The next issue I wanted to move on to, and we will get to the Families First Act. I've been educated this morning already. My good friend and colleague pointed out that in the past webinars, I've been calling it the first families, and he claimed that was because of my British heritage, which I claimed was national origin discrimination. Now we all have witnesses to that, but I'm going to call it FICRA instead. And we will get to that shortly. I know we've fielded a ton of questions on that issue, but before we get there, I want to talk about another issue that has come up a lot, and it's come up increasingly in the last week, which is those businesses that are still operating. They may be essential businesses, they may be non-essential businesses as deemed by the governor, but they are still operating, some of them on a bare bones level. And what happens when you have an employee who says, I don't want to come into work. I am too fearful to come into work. And they don't necessarily fall within what we would call as lawyers a protected leave category. They don't fall under this new law that provides protected leave or existing leave laws. And don't forget that while the focus has been, I'm not going to call it, I'll call it FCRA, the focus has been on FCRA, your existing leave laws and policies all remain in effect. So Dan, over to you on that one. What's the advice you've been giving so far? And let me put a little flesh on the bones of that one. I haven't had any employer who's saying, you know, oh, this person needs to come in because they've got no valid excuse and they're my employee and we need them in. It's much more around facing the real situation where a business is needing to continue to operate, but has got down to so few employees. And I won't name the business, but I had this call last week where the business employs over 50 employees. This is their peak season for the year. Everybody has their peak, and this is their peak season. And they were down to 15 employees out of 50 for a whole variety of what appeared to be very valid reasons. So what advice, having teed that up for you, what advice are we giving, or are you giving, when someone just simply doesn't feel comfortable coming into work?
I think that's one of those questions that we call a thorny one. And I mean, the bottom line is that if the employee is refusing to come to work for reasons that don't make them eligible for leave under FCRA or under your existing leave policies, you don't have to pay them. So that would be subject to your discretion. And if you don't pay them, there's a reasonable chance that they would be eligible for unemployment. You may, depending on the circumstances, view it, if you really need employees to be at work, view it as a disciplinary issue. And you certainly have the right to consider discipline if somebody's refusing to come to work and you've determined that it isn't a proper basis for leave. But there's certainly the potential for public relations implications around taking action against somebody who in good faith is just scared or concerned about the potential for infection. So we suggest that you think carefully about the best approach in your situation.
Yeah, there's a great Kimberly has put in the chat a question that's right on this point. And for those of you who haven't seen it, she's with an organization that delivers installations and installs in homes. They're deemed essential, and they have employees who don't want to go into homes while practicing physical distancing. Only 10 employees, and they're beginning their peak season. It's sort of very similar to what I was just describing. I think that segues in we have no easy answers, of course. We can tell you the legal ramifications. We have no easy answers. One of the things that I'm having more and more discussions about with clients is not only what are the practical measures to enforce safety and following all the guidelines, but what creates a greater perception amongst employees of safety. And this leads into what I will call the face masks discussion. And this does dovetail with return to work issues. But I'm thinking in Kimberly's situation, is there any greater assurance that employees have from an employer adopting a policy now that says all of our employees will wear face masks. And I got this question yesterday from a client who has all sorts of different facilities, and they were weighing the pros and cons of requiring face masks to be worn. Let me be really clear, neither myself and I don't think any of us on this panel want to represent ourselves as medical experts, and I would never provide advice about the medical efficacy of wearing masks. Of course, yesterday, Governor Cuomo in New York issued an order requiring the wearing of masks in certain situations. So we're going to face that more and more and more. The issue that came up for the client I was dealing with was a very large warehouse operation, and the majority of employees were voluntarily wearing masks. It's an essential business. And the concern amongst those who are wearing them is that the few who are not wearing them are placing others at greater risk. Whether that's the case or not, medically, I'm not here to judge that. But the issue to think about for you employers out there is, if you do strongly encourage or require the wearing of masks, what implications will that have, not only from safety and perception of safety, but other legal issues that you should be aware of. And I'm not going to get too much into the weeds of that, but the answer is yes. And OSHA and OSHA requirements rear their head in that instance. And if employees voluntarily wear masks without your direction, it appears that you do not have to provide what would be called PPE training under OSHA requirements and under an OSHA standard. If in fact you do require the wearing of masks, it's an open question right now whether this PPE standard that OSHA has long had in existence would apply. The general consensus amongst us folks who give advice to employers is it probably does, and a prudent course would be to follow that standard. What does that mean? That may sound a little abstract. Oh, an OSHA standard. It essentially means you've got to do some training and some education, amongst other things, if you were to require your employees to wear masks. Those of us who are going to the supermarkets, you can see that the majority of employees in supermarkets are wearing masks. I think I've noticed some don't, so I'm speculating that they haven't made that a requirement yet. But I think that's something to pay close attention to moving forward.
Hey, Peter, here's a follow-up question on that a little bit, in that regards to employers or family-owned businesses that have medical practices or medical facilities or nursing homes where the medical exemptions or medical requirements may be stronger. Can you speak to that? And then I do have a second question, which is a little bit different.
Yes, I'm glad that question was raised. And again, I'll do it at the very high level. So there are sort of, in OSHA land, there are really two different types of what I'm going to call a mask. And I hope with my funny accent, you can understand what I'm saying when I say mask. Mask, I think, is that the right pronunciation?
Yes.
Yeah, I've had fun made of my English accent this morning already when we were doing the warm-up, so I'm going to get my own back now and do my really bad Maine accent in a minute. But there are those masks that are, in essence, comparable to respirators, and in the medical world, those are much more tight-fitting and certainly subject to a higher degree of OSHA regulation. The ones that I was talking about are the ones that all these wonderful organizations, plug for our client LL Bean, who are making 10,000 masks a day now in their Brunswick manufacturing facility. They have great stitchers there who usually make bean boots, and they're out making these masks. I think they're using the dog bear, the totes for those things. So there is an important distinction between the medical facilities where there's a much higher degree of regulation of those masks and a requirement, obviously, in many settings for those masks to be worn versus other businesses. So thank you, Dave, for presenting that question.
One other issue I would just add on the mosque issue is that there may be some employees that, because of a medical condition, have an issue with wearing masks, and you should look at that through a reasonable accommodation lens under the Americans with Disabilities Act, and evaluating whether allowing them not to wear a mask is a reasonable accommodation.
Yeah, great point, Dan. Yesterday I was speaking to a nurse, and she was making that very point that the employees in their population, in fact, who may be more vulnerable, who have asthma and other breathing issues, may also suffer negative consequences from being required to wear a mask. And OSHA does have some allowance for that within the rule that I was talking about. So it has to be, you have to proceed carefully if you go down that road.
Hey, Dan, the second question that I had is, and I'll ask you this one. It says, if another employee mentions a positive case to you or is already aware of one, then what is the protocol for management communication from a legal perspective? In other words, the employee already knows, as in the circle of trust. How would you best counsel them on how to maintain confidentiality?
So if I understand the question correctly, this is an employee who learns of another employee's exposure.
Correct. That's how it understands. Or maybe it's an employee that tells management that they're aware. How does the management communicate when they know that that's true because they are in the circle of the know? How do they respond to that?
Yeah, I mean, I think I would counsel, that generally I would suggest not engaging in, trying to avoid engaging in a discussion about the specific circumstances of another employee as far as exposure. And, obviously, depending on the circumstances, you may need to evaluate, the need to communicate, balance the need to communicate versus the employee's confidentiality considerations. But, if another employee opens up a discussion about an employee, I think it's better to try to steer the conversation in a different direction. Peter, I don't know if you had anything else to add on that.
No, I think it's so, some of those are so circumstantial. We end up, looking at those individual circumstances. What are the business needs? What are the legal risks? It really can be a balancing act. I just cognizant of where we are at 9, I will so take the conversation now to the new federal law. Plainly, that's an issue that I would imagine the great majority of folks who are listening today are wrestling with at a very high level. When I say the new federal law, this is what we'll call FCRA, Families First, is the two F's there. And it was rushed into law by the federal government, signed by the president, took effect on April 1st. And we got a rule or regulations that are described as temporary. I'm not sure that they'll ever replace them. The law has a shelf life right now through the end of this year. And for any business out there, organization out there with less than 500 employees, it applies to you. I imagine most of you have received or seen what we refer to as the poster. And I find I'm referring clients day in, day out to the poster. So if you don't have the poster, you should have it and you should be posting it. It is also a very high level, good, simple resource to start the conversation about the leave issues. Far better than reviewing the 124-page rule that came out that we had to digest and summarize. And we're not going to walk you through, I can hear the collective disappointment, but we're not going to walk you through the individual details of this statute. That would take far too long and we may lose some of you. But Hannah has posted some of our summaries, and we've provided summaries of some of the key issues, and there are a ton of resources out there. So if you're not so familiar with this, you've got some homework to do. But what we're going to talk about is what we see as some of the key issues for family businesses in dealing with this new law. And at a very high level again, because I know we've got some people who I know out there listening today, participating today, who've been immersed in this, and then others of you may have read about it, heard about it, but not know a lot of the details. It's a new leave law. There has always been the Family Medical Leave Act, a federal law. There's also a Maine parallel law here, which also provides family leave, slightly less, 10 weeks versus 12. The FMLA remains alive and well, but it's being supplemented so that in situations where an employee is unable to work, either come into work or telework, because they are caring for a child whose school is closed or a daycare provider is unavailable, there is expanded eligibility for the FMLA. And the most crucial part of it is a paid component, because FMLA, as it exists and has existed for a long time, is not a paid leave unless you can substitute other benefits. And then the other piece that's really, got a lot of issues and questions and interpretation is this, what we call this new bucket of paid sick leave or emergency paid sick leave, up to 80 hours for an employee who's full-time. And the sort of overlap or intersection of those raises some real questions. One of the things I want to say, first of all, on this new law is a very high-level practical comment that I've been saying to clients is, if you are looking to achieve perfection, I don't think that that's possible. And I hopefully understanding that the most important expectation here is that you exercise good faith. And if you're exercising good faith, my assessment is that certainly from the perspective of the Department of Labor, that you are not going to be facing enforcement action from the Department of Labor that would create great problems for your company if you can demonstrate that good faith. The Department of Labor generously gave you a window, I'm a little tongue-in-cheek there, to April 17th. And are we at April 16th already?
Yeah.
So as of tomorrow, the Department of Labor's policy or official position is it can start enforcing the law. It gave this window where if you were exercising good faith, it would not. And so from tomorrow forwards, I suppose if an employee is denied a benefit and a complaint is made with the Department of Labor, there is the potential that you get a visit from the Department of Labor. Let's be practical. This is going to be, a massive exercise, and I wouldn't be losing sleep thinking the Department of Labor is going to visit tomorrow. I think one very big question that we should tackle head on for family businesses out there, and it's a question we face a lot as well. We are a small business. We're less than 50 employees. I've heard or read that we can be exempt from this law. So can we simply say or apply somewhere to say this law doesn't apply to us? We are a small business. We can't afford it. We would love to provide these benefits to our employees. We're closed. Dan, what can we tell people out there about what I'll call the small business or small employer, because it's more than just business, exemption? Does it exist, and what can a business do to use that exemption? And I guess I'll throw out one more question. How broad is that exemption?
So first, the exemption has a fairly limited application because there are 5 different reasons that employees may be eligible for leave under FCRA. And only one of those reasons does the exemption apply to. And that is if an employee is caring for a child whose school or daycare is closed or unavailable. And that's the reason that they need the paid leave under FCRA. This exemption for under 50 employees may apply to you. The employees may be eligible for paid sick leave for the up to 80 hours of paid sick leave for 4 other reasons. The employee can't come to work because they're subject to a quarantine or isolation order from the government. The employee is actively seeking a diagnosis for COVID-19 and has related symptoms, or the employee is caring for an individual who is in either of those situations. Either the person they're caring for is subject to an isolation or quarantine order, or the person is subject to advice from a doctor not to come to work because of COVID-19 reasons. The core criteria for having the exemption apply to a small employer, under 50 employer, is that providing the leave would threaten the viability of the business as a going concern. So that is the core requirement for eligibility for the exemption. And the law prescribes 3 different examples or factors that might demonstrate that providing the leave would be a threat to the viability of the going concern. And I don't have those off the top of my head right now. So I can review my notes and explain them, but you should make sure that if you're going to take advantage of the exemption, that you're able to document, and we would recommend generating documentation internally that would establish that you qualify for the exemption.
One important thing, just to chime in, is there is no application process.
Yeah.
It appeared originally under the law that there would be, and I think Department of Labor had a sort of gotcha moment saying, wow, we could not possibly handle the application. So if you're a small business, you believe you're exempt, it's a narrow exemption, but you don't have to apply. You can self-declare. And the materials that we've put out there, particularly one we put out on April 3rd, and Hannah's providing things, has the list of criteria. I gave advice to a client just on Friday, and they are documenting, and they're going to send it to me. I said, send it to me, I'll review it. They're creating what I would call the business case for their exemption. And one other point that we should make on this small business exemption is you don't necessarily have to make a one-time decision on the small business exemption. It could be that after a number of employees have gone out on a protected leave, you get to a critical point where you can't support more. The new rule certainly indicates that you could apply the exemption at a later point for specific employees. Of course, that creates some employee relations issues. This is not to sound self-serving, but if you are considering the small business exemption, that is an area where I think you want to get some legal advice about, would that pass the straight face test? And if it does, how do we best document it? So that's sort of a high-level review of that exemption. Another issue that I wanted to focus on here as well is the leaves. I think this is important. I think many of you may understand this, but to be really clear, the leaves that we're talking about, so the new sick leave or the expanded FMLA up to 12 weeks, do not apply if your employees are furloughed. And so we're all on the same page. A furlough is typically a situation where you no longer have work, or you've had to close and you've told your employees that they are on temporary layoff, that they will not be working, and you would anticipate that they will be returning to work when circumstances change. In that instance, even if an employee has to stay home because he or she is caring for a child, so would not be able to work even if you were open for business, the federal government has now said this law does not apply to those situations. And that's, I think, a critical clarification that came out in this rule. That particular interpretation by the federal government is now being challenged. We saw this yesterday by the state of New York, who disagree with the rule. That's for us to be concerned about, not you. You should be following the rule. If the rule gets changed by a judge, then there will be more information to share. We don't want people to be too daunted by all that's going on behind the scenes. But that's a really sort of important distinction to understand on that issue. Dan, were you going to add something?
I would just add a note that in addition to that employer exemption, small employer exemption, there also are the potential for exemption of specific employees who are either healthcare providers or work for a healthcare provider, or emergency responders. And one of the issues in the New York litigation that you were mentioning, one of the challenges is how broadly the Department of Labor has defined those exemptions, particularly the healthcare provider exemption. And that the regulation very broadly defines healthcare provider as basically any employee working for a provider or a medically related organization. So that's
right.
a very broad.
Yeah. So for those of you out there, and it sounds like from an earlier question, who might be considered healthcare providers, one thing to analyze carefully is, does that cover every single employee within your organization, or do you designate certain employees? And we've worked with multiple clients now on analyzing that and making the distinction. And Dan, Dan is in addition to my colleague who gives me a hard time about stuff, he also actually keeps me straight about the law. So Dan, am I correct in saying that the healthcare provider exception is much broader than the small business exemption, in that if I am a healthcare provider and I am exempt, none of the provisions of this new law apply?
That is correct. And it also, those exemptions, the emergency responder and healthcare provider exemptions, are ones that you have the flexibility, if you qualify, you have the flexibility to apply those selectively. So you can make a decision that certain of your employees are essential, and therefore you can't afford to give them the leave. But others, you could choose to extend the leave to.
Again, there's a lot of detail in this law, and we'll stay at the high level, and there are a lot of resources out there. One of the things that we have just been working on with several clients is a new form, and a form that can be completed by the employee, provided to the employee, and we actually used, and it's a good resource. We've now tailored it to what we think is our clients' needs here in Maine, but I'll give full credit to SHRM. We looked at a variety of different forms out there, and we liked the SHRM form, and we've made some edits to that SHRM form, and we're tailoring it to the needs of different businesses. There are questions that some clients had about whether or not to include intermittent options in there. But I would urge those of you who are subject to the law and are not exempt from the law, that there are some documentation requirements. And why that's important is not only for your own record keeping and for making sure you're applying the law consistently and documenting it. It's clearly going to be an important issue when the tax credit that comes with providing this leave is applied. And in an audit situation, the forms that you have employees fill out and the way they've been prepared is to ensure that you have the requisite documentation to show that you provided the leave. From a legal point of view, this is what keeps us in business as lawyers. We see two big issues with compliance with this law. One would be that you interpret it too narrowly and you don't provide those benefits to employees. And so you have later an employee complaint or lawsuit saying, I should have been covered and I wasn't. And then the flip side of it would be the federal government later, when you have applied tax credits, saying you applied the law too broadly. You gave it to pretty much everybody and you spent all this money on the leave, but in fact, you didn't follow the requirements of the leave. So that's kind of the balancing act. And this, in today's world, talking about lawsuits sometimes seems a little bit inappropriate or excessively cautious, but there is no question in my mind that when we get towards the end of this or at the end of this, that's what we're going to see. There's going to be plenty of lawyers who represent plaintiffs' employees who are going to be looking at where our clients allegedly have not provided the benefits they should have in this situation. Another important issue on the first families, and I see some questions coming in. So Dan, if you are reading them, or Dave, we may want to tackle some of them as well. But I see a big issue on the horizon, and this is in the spirit of looking to return to work. I said we wanted to focus on that. The big issue is, in my mind, is going to be, all right, we're ready to open. We're ready to bring people back to the office. We're ready to interface with the public if we're a public-facing business. We've been economically hurt, and so we're going to bring people back, but we can't bring everybody back. And there's, I think, a obvious area where you want to bring back your best employees. You want to bring back the employees who are going to be, the best team players. You're going to want to bring back the employees who are going to be the most flexible. You may be leaner as an organization at that point. And how do you do that in a way that's efficient, that allows you to do it, but also is mitigating some legal risk? And why I raise this issue is, by way of example, if it turned out that the last employees you brought back were the ones who had exercised leave rights under this new law, there right away is a very obvious claim for an employee to bring. And I think it's fair to say, at the end of all of this, there will be many businesses who can't bring everybody back. Maybe the business does not come back as quickly as hoped. Maybe the business doesn't come back for a long time, or maybe your financial situation means that you simply can't afford to bring everybody back. What we'll be working with clients to advise is, how do you set up not a cumbersome, an efficient process that allows you to document who you brought back, when you brought them back, and why you brought them back. And I give, and Dan does, our firm gives a lot of advice on eliminating positions, and how do you eliminate positions and do so in a legally compliant manner. Frankly, bringing people back is sort of the same exercise. And I think if you have 10 people who work in one operation and taking phone calls in your customer service center, and you believe you can bring 6 back, you don't want to just give the supervisor, complete discretion without any criteria. I think you want to set some structure up to do so, because these laws, I should add, first, families first. There you go. That was the first time I got it wrong again. That woke Dan up. He looked up from his notes for a second. Have non-retaliation provisions. So if you exercise your rights under this law, as you do with the FMLA or the ADA, you are protected from retaliation. So I think that's a big question. Do we want to tackle a question or two out there?
Peter, a couple of the questions, but let me throw this one out there because this one came in off of the, not on the chat line, but it's a question of, I'm a family business, and what are my risks bringing back my family members first? Because that's what we do. We take care of family first.
Yeah. I've faced that situation before and we represent quite a lot of family businesses, large and small. And I'll be practical here. I think that's very understandable. I think that, it is a business that's, being built by the family. It supports the family. And, I think that it is going to be reasonable and appropriate to do that. And if I face a claim from an employee who says, hold on a minute, it's unfair, there's preference being given to the family, I'm not going to be too concerned about that. Every case, of course, is different. So if the person who makes that claim had filed a sexual harassment claim against one of the family members, the facts can then look different. Dan, what about you on that one? Are you losing sleep over putting families first?
No, it would be consistent with the name of the act that you finally have gotten right.
So yeah, that's a good question. The other thing that we should focus on a little bit is if I said already that if you're furloughed and you cannot, there's no work available, business is closed, then the new law does not apply. But if it does apply, Dan, if I'm out on leave, let's say I'm using the expanded FMLA, I'm caring for my child whose school is closed, I've been out 5 weeks. Am I protected by that leave so that my job remains insulated from any furloughs, layoffs? Because I'm on leave, don't I have a legal protection? What's our advice on that?
Well, the law does provide protection for reinstatement of employees who are taking leave under the Families First Act. But there's an exception for circumstances in which the employee's job is eliminated or reduced for reasons unrelated to their having taken leave. So if you have legitimate business need to reduce your workforce that is unrelated to the employee's taking of leave, you have the ability to go ahead and make those business decisions. That doesn't mean that you may not be at risk of a claim that you have denied somebody reinstatement or otherwise retaliated against them for using the protected leave. And for that reason, we recommend that you carefully document the reasons why you are deciding not to bring the person back. And obviously there are significant economic implications arising from this whole pandemic that may very well justify the decision not to bring somebody back from leave. But you'll want to document those in the event that you ever receive a claim on that ground.
Hey, Dan, and just a follow up to that, because one of the questions that came in was they're looking for guidance on return to work after an employee is COVID positive or negative and or just not feeling well. They're trying to devise what you would call a chart for bringing people back. In other words, what are the, what's the layout? How does it look? How's the grid, to try to be equitable and fair across the board? So Dan, Peter, thoughts on that?
I'll take a first crack at that, because that's where I was headed. And because it's a tricky question, I was just going to punt it over to Dan, but I'll take a shot at it, and then he can mop up after me. And this again is in the spirit of okay, when we're back fully operating, hopefully, or back in business, what can we do? What can we ask? And can we have a checklist? Can we send I got this yesterday from a client. Can I send a questionnaire out to all employees and gather information? Pre-pandemic, you would have seen Dan's look of horror on his face that we would be submitting employees to medical examinations, medical inquiries. The ADA would plainly be violated. The whole world has shifted, including the EEOC, who have put out guidance saying previously what was illegal is okay now. I'm making that very simplistic, but medical examinations and medical inquiries in a pandemic world are acceptable. There are parameters that relate to them. Confidentiality remains very important. So information that you're gathering about your employees' temperature, symptoms, tests, all of those different things remains, of course, confidential medical information. It should not be kept in the personnel file. It should be kept on a narrow need-to-know basis within your organization. Only those who have a need for that information should receive it. But again, I alluded to this earlier, sort of the competing risk world. I believe that safety should be your highest priority when making decisions about opening up your business, and the safety of your customers, the safety of your employees, the safety of your stakeholders. And so, there is, I think, a reasonable prudence in thinking about, do we have a standard set of questions? And I like the idea of a standard set of questions, so everybody's being asked the same questions. And those questions are being reviewed by, a core 1 or 2 people within your organization. You don't want to give too much discretion and allow one person to decide, oh, it's fine for this person to come back, and someone who's had exactly the same situation is not allowed to come back yet. So some centralization of that decision making. But, Dan, I think we're in a place right now where we can certainly ask somebody about their symptoms. I believe we can ask whether they're symptom free. What's your view on I know this question's coming, and maybe you've got it already. So are we able to ask our employees whether they've been tested? Are we in a position, this may be wishful thinking, to say that before anybody returns to work, they must have either been tested or they must have a doctor's note saying they're able to return to work? And I'm including in that group of employees some employees who have not reported any symptoms. Can we go as far as that?
Yes, I believe that we can. We can ask for, and the legal standard that governs is, will the employees return to work potentially pose a direct threat in the workplace? And the CDC has issued some fairly recent additional guidance on when employees who are either symptomatic or asymptomatic, but who have tested positive, when they can safely be back, in the workforce and no longer pose a risk. we've developed a guidance document. I don't know that we've actually published it yet on return to work requirements. But and maybe Hannah, you can indicate in the chat whether we already have that, or whether we've
Dan, if I took the camera to the left here, it would be sitting right there on my desk with a few red marks on it. So
right. We plan to get that out this week, but that will be, so we can follow up and make that available when Peter finally gets around to doing it.
I've just been hanging out in my personal office and not doing anything for the last 3 weeks. Dave, I think, looking at the time, suspect that we have probably used up our time. There are obviously lots of other issues and questions we can cover. Maybe there'll be some questions at the end. I wouldn't mind addressing some OSHA issues, some workers' comp issues, a few other things like that. And obviously, if there are more questions, we can find a way to get back to people and answer them as well. I think you're on mute, Dave, if you are trying to speak.
I'm going mute now. How's that? There we go. There we go.
You sound so much better on mute.
Well, most people would agree with that statement. So no, thank you both. What we're going to do is I have a short discussion point in terms of the HR side, and then I'm going to open it up bring all the panelists on, bring Linda back on, and do kind of like an ending wrap up of some of the questions that will be coming in that we either haven't answered or that we have from participants that gave their questions in beforehand that we haven't answered yet. So thank you both for that. One of the things that I get a lot of questions on in regards to HR is Department of Labor and unemployment. And the reason that this question came up in terms of, how do we handle this? What do we tell our employees? How do we, tell them they can get unemployment, they can't get unemployment? How does it work? And, look, we've been being very clear with our clients and others that have called that the reality is they could be eligible for unemployment. And the reality is Department of Labor gets to make that decision. It's not the employer's decision to make. Now, having said that, the Maine DOL yesterday, April 15th, provided an update on, or an FAQ regarding COVID-19. As a matter of fact, I'll put the link in the actual chat room. I'm actually going to drop it in right now. And it is the Maine gov /labor / blank. But the reality is that this document is actually really good. We got it late, early this morning, I should say, read through it. It does answer a lot of questions regarding what the Maine DOL is talking about in terms of who may be or may not be eligible for unemployment. Talks a little bit about how employers can provide guidance. It provides great answers in regards to how to file for unemployment. This may be something that certainly employers, if you are going to provide a furlough or you're going to be doing a layoff, it's a great document that you can provide to your employees. They're eligible for it anyways, they can find it, but this may be able to answer some of their questions that you may not be able to answer, and we would advise not to answer directly. The reality is unemployment is up to the Department of Labor. It's not up to us. We pay into it, but that's the case. And one of the questions center upon if I part-time furlough them, or if I put them out part-time, how does that work? And how many hours? What if they're per diem? This Q&A does provide a lot of those answers. Although it is interesting in the questionnaire, it does also say may or could. Of course, every individual person individually has their own story, and employers are going to deal with that. And as you know, it's backed up at the DOL quite a bit. Monday through Wednesday, they're doing the alphabet, A through H, I through Q, and then R through Z for people to file. So employers are getting a lot of calls and questions. Hey, I can't seem to get a hold of them. Can you help? The reality is that you really can't, but you can certainly provide them this document as part of that information. The other questions I'm getting from employers in regards to unemployment is, well, we have a 1099, somebody's a contractor, or maybe I'm a self-employed employee who, as part of the organization or one of. The reality is that according to the there's going to be help for these people. As of this morning on the Maine Department of Labor's website for unemployment, it still says that there is no action to be taken yet for these individuals, that help is on the way, but there's no way for them to file. And if you do file, you'll be denied. So it says to please wait for that action. So I do know that employers are getting these questions because, of course, their employees are looking to them for answers. I would tell you to continue to be very, positive and upbeat about, they will get answers, they will get help. There's even, according to this update, that the Governor Mills has agreed to provide the additional $600 a week in regards to benefits for unemployment for a specific period of time. And that is supposedly going to start as early as the week as April 20th. So that is next week. So anyways, bottom line is that there is help on the way. Peter, I'm just going to throw it back to you for one quick question in regards to unemployment, because we get it quite a bit. Sometimes employers are concerned that these employees are going to get this additional $600, for example, and that amount of pay may be more than what they make. And it is very clear in the FAQ that if employers keep them on in a furlough status and they need them back, that they can come back to work, and that they need to be able to be eligible to come back to work. But some employees maybe, oh, wait a minute, I want the short-term additional money. How does an employer handle that situation in regards to saying to their employee, we need you to come back? And they say, well, I'd rather not, I'm actually getting paid more.
I'm back on, yes. Thorny question. Dan had said earlier, we have some thorny questions where the math works that way. And we've had certainly that situation for a number of different clients. It presents the challenge of having somebody right now come back to work and be back at work and receiving less money than they might receiving benefits, and the person knowing that they were called back and they may have peers who are not called back. We have a business where they employ 20 custodians, and they don't need 20 custodians right now, but they might need 5 custodians. And the 5 custodians who are called into work are in exactly that situation. Clients are tackling that in different ways. And one way is some clients have actually offered some premium or incentive pay for those people they've needed to call back in. That's a business reality, and whether that can be afforded or not in this time is difficult. Clients are being careful not to call that hazard pay, by the way, but probably doesn't sound the message you'd want to send. The alternative, sort of legal, but less, I think, practical, is that a person is only eligible for unemployment if they are ready and available for work, but there is no work. So strictly speaking, if you have work for somebody and then they decline work, then that will impact their eligibility. I wasn't born yesterday, so I realize that the person who says they're not going to come in may well have a perfectly good, and I'm not being a cynic, they may have a perfectly viable, valid explanation. So many of the ones we're hearing, I mentioned that business where they had 15 out of 50 employees now working. So many of them lived with a compromised or vulnerable relative. And I get it totally, that the notion of going into a workplace and then coming home each day, having had exposure to those different people, cause concern. So as you can tell, Dave, from my answer, there's no easy solution unless you have the ability to at least match or exceed that pay. And just so we're all clear, it's our understanding that $600 of federal money is in addition to the $445 maximum in Maine, so that's $1,000 a week. And I haven't had time to look at the latest guidance, and somebody correct me if I'm wrong, but I got a question about somebody who's got reduced hours, and there is an ability to still receive partial benefits for even if the employee is working reduced hours. And it was our interpretation as of yesterday that that $600 would also be applicable to the employee who is working reduced hours. And I think that was one of the questions that came through.
Yeah,
Dan, are you ready? Or Dave, there's a couple more questions. Are we ready to tackle any of those questions in the chat column?
Yeah, well, one of them is full-time employees get only part-time hours. Are they able to collect partial benefits? According to the FAQ, which came out, which is a clarification of what we understood, the answer is yes. They can apply for it. Whether they're eligible for it will be up to the DOL, but the reality is yes, they are urged to apply for it. The next question is, what if you have a 1099 contractor that works in a different state but provides services here in Maine? Do they apply to the state they work or live in? That is a tricky question because they're 1099 and the guidance hasn't come out on 1099 yet. 1099 employees typically have not been able to file for unemployment. They are going to be able to file for unemployment now. So the answer is there is no answer to that question unless Dan or Peter, you know the answer. I've not seen that yet.
Yeah, well, that gets to an issue that you teed up first of all. I'm being very cautious with clients and telling clients to be cautious about being the definitive voice on unemployment for individual. We don't want to promise, we don't want to guarantee. I understand why people want to support and give some advice. In that situation, I'd probably say to that person, there's probably no harm, and someone can correct me again if I'm wrong, you may want to apply in both. And what I always say is tell your employee that they should be honest, they should provide all of the information that's required, and you know the chips will fall where they may, and you will, when asked, you'll supply the honest information, of course, to unemployment, and the decision will ultimately be made by the state here in Maine or wherever else that person actually resides.
So as we get ready here to wrap up with the last 15 minutes or so, I thought what I'd do is I'd bring Linda back on as well. And there's a couple of questions that have come in and I thought I'd just throw them out here and we'll go from there. So Dan or Peter, what should construction-related trades, for example, do consider given the revised OSHA safety and COVID-19 guidelines? What are some of the most important points to reinforce in your view legally?
Dan, are you ready to tackle that one?
Peter has no idea the answer to that.
What the heck? No, I felt like I was dominating too much in it. I should generously share.
You know, the guidance from CDC and OSHA is constantly evolving, and you know, one of the examples of that is this issue around face coverings. And you know, a couple of weeks ago, I was telling employers, you know, you really shouldn't, you know, if you're not in a position to supply COVID-19 approved face masks, then you probably shouldn't be requiring that in the workplace. So, you know, I recommend that, you know, you in the construction trade, and I haven't looked specifically at that issue, that you look carefully at what the CDC guidance that's out there, and you know, enforce as best you can the social distancing. Consider requiring face coverings, institute routine cleaning in the workplace. All of those types of measures that have been recommended to mitigate the risk.
Yeah, and I just echo on that. So you know, as these things keep changing, coming out each day.
You lost your video a little bit there.
Sorry, as these things keep coming out every day, I think, you know, we lawyers can be guilty of over-document or advising over-documentation, but I think you want to be able to show you're showing your superintendents, your project managers, whomever it is on the site, have been equipped and given the very latest guidelines, and there is some degree of documentation to show how those are being observed. You know, just down from where I'm by myself in one of our offices, and I still see the construction sites in operation close by. And I realize again that I mentioned this before, but I saw it just the other day. Walmart was one of the first recipients of a wrongful death lawsuit as a result of an employee contracting COVID-19 allegedly at a store. And that lawsuit will then focus on what guidelines were out at the time and what evidence is there that the employer in good faith sought to enforce and comply with those guidelines. And you don't want to be making it up as you go along or saying, yeah, I think we did this on this day. You know, your safety sheets, your notes, and all of those other things I think would be very important to have to track that. You know, hopefully nobody finds themselves in that situation with such a tragedy, but you know, it of course is part of the reality now. On the OSHA issue, OSHA did issue new guidance. We put out an alert, I believe it was, the days all blend, but a few days ago, about what's your obligation to report to OSHA. And it does, again, depend on the industry that you're in. Healthcare and others have a somewhat of a higher duty. The general practice is you need to have some objective evidence that the infection occurred at work or as a result of work. And then that would be an OSHA reporting requirement.
Okay, next question that came in, you probably saw, is we furloughed all employees and are now looking to open. We have received the PPP and would like to bring back in, the needed employees. Some may not want to come back due to the return to the situation that they are, limited within that period. I'm paraphrasing here. What do we really need to do in regards to this? And do we have to pay the employee an average and same amount regardless of the risk for these sitting at home versus those coming in to work each day for the risk?
So I think this question really goes to the eligibility for loan forgiveness under the payroll protection program. And the general rule is that employers have the ability to get loan forgiveness for payroll costs if they and for other costs if they maintain a full-time equivalent enough full-time equivalent employees to match those that they employed in one of two prior periods. And there's a window of time in 2019 that can be looked at in determining the number of full-time equivalents that need to be matched. And there's also a window of time earlier this year that can be looked at. And generally the lower number of full-time equivalents during those two periods is what establishes the eligibility for full loan forgiveness. I think this question goes to the question of, well, if I've put people out and now I want to bring them back in order to, because I've got the payroll protection loan, what if they don't want to come back? And what, that's going to present a challenge to my ability to get full loan forgiveness. Well, you certainly have the ability to pay them, even if they're choosing not to come in and treating it as paid leave. And I believe that that compensation would be recoverable. I should note that. Yeah.
Dan, I have a question for you. Sorry, I interrupt you, but could I, if someone chooses not to come back in, and I want to use PPP funds, can I reduce their pay? Can I pay them less? Is there any problem with that? And I'm throwing that out as a question I haven't been asked yet, and just occurred to me.
Yeah, I mean, there's certainly nothing to prevent you from reducing their pay, but you are only going to get loan forgiveness for the payroll costs that you incur during the 8-week period after you get the loan. So, and there is a, so there may be a question of whether the employee who is receiving reduced pay is a full-time equivalent, or only part of their hours should be included for purposes of doing the full-time equivalent calculation and comparison.
Can I just mention one other thing, and it ties into that, and thanks, Dan, that was a great answer. I've been educated. We're dealing with, plainly businesses looking down the road and seeing that the salaried employees have either significantly reduced workloads, or in fact, there's just not the money to pay them. So we've been giving it's somewhat easier for the non-exempt hourly employee, to deal with that issue. Still painful for everybody. I'm not trying to minimize that, but with the salaried rules and the exemptions under the Fair Labor Standards Act, it's a lot trickier. And so we've been advising clients on reduced work weeks and commensurate reductions in salary. And some of you will have seen it in the media. Some of the more well-known companies get attention in the media, and it's announced that there's a 20% reduction in salary, or 10% reduction, or 5% reduction. Tread somewhat carefully when you're doing that. There certainly is an option to reduce salary. Remember that it always has to stay above the minimum threshold here in Maine, and I believe that's currently 36,000 based on the Maine standard for an exemption. But that's an issue we are getting questions about every week. And again, you have to proceed carefully. One practical tip on this is, if you do it on a week-to-week basis in terms of reducing either the work week or the salary, you probably may get unwelcome attention from the Department of Labor. Their historic guidance on this issue, and it goes pre-pandemic, is it should be for a period probably in the region of 3+ weeks, rather than what they would describe as on an ad hoc basis. Dan, have you got anything to add on that? Yeah, I know you've given a lot of advice, and I have, on salaried employees, furloughs, reduced pay. Anything we're missing?
Yeah, other than to reinforce that it's something that you should be cautious about, and if you have any questions, consult professional, get professional help. The one thing that I would add on the payroll protection program is that for purposes of loan forgiveness, you can't get you can't get both a tax credit under the Families First Act and include the payments to employees in your payroll costs for purposes of loan forgiveness under the payroll protection program. So that's something to be sensitive to as you as you both lay out a compensation strategy for those 8 weeks for your employees, and as you consider taking the tax credits under the Families First Act.
Dave, do we have any other topics, or you want to wrap it all up?
We have about another minute or two. There was one other question that came out that I saw in regards to just, and this, Dan, you may be able to answer in regards to the Leave Act, and that's the confusion sometimes with the Emergency Family Medical Leave Act and the current Family Leave Act. Can they run conjunctively? Can somebody use both? Can they get basically 12 weeks for one, 12 weeks for the other? How does that work in regards to that? And it's just a quick question that popped up.
So generally, any leave that is taken under the expanded FMLA provisions of the Family First Act, and that's the 10 additional weeks that employees are entitled to pay if they are home caring for a child whose school or daycare is closed. Generally, that counts toward their annual 12-week allotment of FMLA. And if an employee has already used FMLA for other reasons during the leave year you use for purposes of determining FMLA eligibility, then their amount of leave that they would be entitled under the expanded FMLA would be reduced accordingly.
Okay, Linda, anything you would like to add as we wrap up here today? And you need to come off mute.
Yes, just real quick on communication. I know we're getting a lot of questions on a variety of situations and scenarios, and the advice we're giving is, lead from the heart. Think about, who's being impacted. Create your messaging with empathy and collaboration with those folks who, are leading the charge in terms of the CP, the government, the attorneys, and really just stick to your authentic voice, incorporating your values and where you want to be when we come out of this.
Peter, Dan, any final words?
Can you hear me?
I can, yes.
Well, no, I really want to thank everybody, well, IFOB, obviously, for hosting. It was a great organization that we get a lot out of. And I would say to people that, we, in a way, we are able to, the tip of the iceberg. There are so many questions. And, I've said it before, I think the two things that I really, when you're ultimately making your decisions, obviously they have to be about the health and success of your business. But most of all, I'm finding all the employers who are contacting me, that they're very much first thought and concern is the health and safety of their employees, and how do they stay in business. And that's why there's so much to discuss. There's so many difficult decisions to make, and it's an area where we have to move fast, but getting the best guidance you can when you make those decisions, and then being able to move on.
Dan?
I don't have anything further to add, rather. I wanted to thank IFOB for hosting it.
No problem. Hey, I will leave you with one final word as we wrap up today. Remember, employers, HR, business owners, family leaders, what you do today, what you do now will make a difference in how people think about your organization and about your brand, and how you present yourself today, and how you balance the needs of the business as well as the needs of the employees is critical to your success in the future. So I just want to remind you, it really does matter to stay in touch with your employees, even if they're furloughed, and say hello, see how they're doing. It makes a real difference. Again, IFOB, thank you so much for presenting this. As we wrap up the show today, I know Catherine has said very clearly that there will be a questionnaire that's going out. And so we want to thank her and the IFOB for providing this time today. And there's Catherine out on the screen. So thank you, everyone. Have yourself a great day. We appreciate it, and enjoy the rest of your week.
Thank you.
Bye-bye now.